the matter of Amber Thompson versus Dustin Musel. Mr. Musel is present. This is a show cause against Ms. Thompson regarding a fine that was ordered back in 2024. Has not been paid. There's a $100 fine. Given the amount of the fine, this is the first time the court has set the matter. I will do a one-time adjournment, about 30 to 60 days, depending on the court docket, to give her one more chance to see if she appears. If she does not appear, the court would likely then order a bench warrant in the amount of the fine plus costs. Sir, do you have any questions or anything that you'd like to say?
Yes, this is the second time this has happened, and you adjourned it last time. I've tried to reach out. I call on my times that you've ordered. I've even tried to compromise. She basically says the rules that Cadence, she would only like me to see him a couple times a month. That's
today's court hearing. Today's court hearing is only about her fine that she got back in 2024 and hasn't been collected.
All right, I'll have to wait for the other paperwork to catch up. I put in a complaint.
Okay.
I still haven't seen my son, so.
Okay, well, certainly when that's processed, we will address that, but we're all set for today. Okay, sir?
Thank you.
All right, thank you. Court is back on the record. We'll call the matter of Cassandra Barber versus Chris Stokes, file number 19-18004DS. Do we have the parties on that matter present? All right, if you are present, I need you to unmute. Let me know you're here.
I'm here, sir.
I'm here.
All right, we have both parties present, and Mr. Stokes, this is your objection to a child support recommendation. Is that correct?
Yes.
And what would you like to say in support of your objection?
I just started working the day before yesterday. I'm getting everything filled out for a review and for it to be taken right out of my check. And I was just hoping we can wait until that's done before raising it or anything.
All right. So don't you have a date in front of the judge also in January?
I think so.
I see an order saying that you had a show cause back in October that was adjourned to January 23rd before the judge to monitor you making payments of $500 in October, November, and December. Did you make that October payment?
Yes, I've made all the payments.
Okay, excellent. All right, so is there anything about the support calculation that you feel was inaccurate?
I just can't afford it right at this moment. So that's why I was hoping I can get this review and everything done first. And we can go from there.
What do you mean by review?
I can't afford $750 a month right now, on top of the other child support I pay.
All right, I thought this was for 500. Is that accurate?
What I got in the mail said 750.
All right, let me take a look to see if I can find that.
Your Honor.
Yes.
I believe it's an ordered on arrears recommendation objection. So the current support wouldn't be changing. I believe it should be identified under number 13 on the USL.
Okay. Looking at IC's got 500 on it. Is that your understanding? It was 500 before.
Yeah.
500 was the current support. Previously, it was just $50 ordered on arrears. That ordered on arrears increased to the $250, bringing the grand total to $750.
All right, so is that $750 a month?
With the new ordered on arrears.
Is all arrears that he's paying at this point?
No, he has a $50 a month obligation, but because his arrears balance is so high, we did need to adjust the order on arrears from $50 up to $250 a month.
Okay. Ms. Barber, anything that you wish to say? Ms. Barber, do you have any questions or any input?
No, I don't have any questions.
Okay. All right, so I certainly understand your position that you might be struggling at the moment, but this recommendation does follow the guidelines. My understanding is you have a pretty decent balance out there right now.
Yeah, that's why I'm just asking for a little more time.
Well, we're gonna put this into effect. I'm gonna deny the objection because it does seem like it follows the guidelines appropriately. Obviously, pay as much as you can at this moment. You've got that hearing in front of the judge to address those other payments, so if you're making a good dent into everything, then you might get a little more time to get yourself back caught up, but based on the objection, I don't believe there's any legal objection not to grant or not to deny the objection.
I'm just not going to be able to pay it. Like I can't.
Well, it followed the appropriate guidelines, so I am going to deny the objection.
Okay.
You two are all set for today. Thank you. For next call, the matter of Naomi Griffin versus Jonathan Griffin. File number 25-20083 DM. Do we have the parties on that matter present?
I'm present.
Thank you. We do have Ms. Griffin present. It was set for 9:30, so it's now 9:35, so certainly proceed forward without Mr. Griffin. And man, this is your objection to a child support recommendation, is that correct?
Yes, yes, sir.
And what is the basis of your objection?
Because I am, I've like lost my state benefits that I was receiving. Plus, my employer, we are in our off season, so I've lost a lot of hours and my pay was reduced. And we even went on like a 2-week shutdown. And so I was just wondering if we could have some child support established other than just like, because I know that we had agreed to defer it all like medically to the medical insurance. And so I was just trying to see if we could get some actual child support so that could get some help during this time. I'm currently working on trying to get a third job to try to support all 4 of the kids.
All right, so previously you agreed to deviate to just the medical only, but now you are requesting that child support be ordered based on the support guidelines, is that correct?
Yes, sir.
And as part of your, well, have you guys officially finalized your divorce yet or not?
No,
Doesn't look
this
like-
is like the beginning process of it all.
All right, well, given the fact that the deviation was not based on some type of award of property, you do have the right, I think, to have support ordered. So I would grant the objection and indicate a new recommendation should be prepared without any deviation. Your caseworker might have a question or two, so let me check. Any questions regarding the information?
In regards to the state aid, the information that we have appears a grant ended in the end of October, but another grant started in November. So I guess I would just want to find out if there's an effective date she's aware of for that.
Ma'am, did you hear that? And is there any assistance either starting soon or that has new assistance that has started?
So I am no longer receiving my childcare because my childcare provider does not take state assistance, so I'm paying all that out of pocket. And my food stamps has been reduced. I'm not sure the effective date. I believe it'll be the 21st because that's when I'm set to receive my payments. That I'll have that reduced amount on
Okay.
that.
So it's the medical, the children are still receiving the medical assistance though, correct?
I believe so, yes. However, on that, one of my twins was not ever listed. I was listed instead, as one of the beneficiary. I was trying to talk to somebody through, friend of the court about that, just because I didn't, that wasn't right.
Right, so ma'am, if you didn't previously submit childcare expenses, you do have the ability to do that also. So if you now have childcare expenses, you're able to submit that to be considered as part of the formula. So I will give you some time. If you can, I'll give you both parties another 14 days to submit any additional information they want regarding the calculation. So if you do have childcare expenses, make sure you submit that.
Yes, sir.
As well as any other potential changes. But I will grant your objection, give the parties 14 days to submit any new information, and then a new recommendation will be prepared.
Thank
Any
you.
questions, ma'am?
Yeah, how would I, do I go up to friend of the court to submit that paperwork then?
Yes.
Okay, awesome. Thank you. Other
Alright.
than that, no, I don't have any other questions.
All right, thank you.
Thank you.
Back on the record, we call the matter of Ashley Begbie versus David Wasowski, file number 14-15600 DP. Do we have the parties on that matter present?
I'm present, Your Honor.
Thank you.
Okay, I'm unmuted.
All right, sir, thank you. And Ms. Bagby, this is your objection to a child support recommendation, is that correct?
That is correct, Your Honor.
And my understanding is you've also submitted a recent request for a review of support, is that correct?
That is also correct, Your Honor.
All right, in front of the court, is that review then going to be completed based on this case?
It is, Your Honor. The forms were generated on Monday to be mailed to the parties.
Okay. So what I'm going to do, ma'am, is I think it's appropriate that there is a new review going on, that we let that review happen. And then as part of that review, address any orders on arrears. So in that sense, then the objection. This is just a recommendation to order on arrears, is that correct?
Yes.
All right, so in that sense, I will grant the objection. We will hold off on making that decision until we see what the new support recommendation looks like, so the arrears amount can appropriately be calculated. Any questions regarding that, ma'am?
No, Your Honor.
Sir, any questions?
Yeah, does that mean that they're gonna retroactively adjust her stuff from all the time that she hasn't paid?
Well, no, the arrears aren't going away.
Okay.
There's going to be a new child support recommendation. She's still going to owe on the arrears, but the amount that we collect on the arrears is ultimately going to have to take into consideration what that new recommendation is.
Oh, so it's just the arrears are gonna, the amount is gonna remain the same, just the amount of collection.
I am not ordering that anything that's back owed goes away. We're just going to prepare a new recommendation and then address the arrears, okay?
Okay, thank you.
All right, so both parties obviously need to make sure they complete those questionnaires that are sent out so a new recommendation can be prepared.
Your Honor, I'm confused if I may ask a question.
Sure.
I'm objecting to the amount of the arrears also. Is that going to be addressed?
I
Was hoping, I thought that there was going to be, that today we were on the record to schedule hopefully an evidentiary hearing where I could present what has happened since April 2022 when I suffered major nervous mental breakdown, and then I was having psychological breakdowns, and I was recently, about a year ago, diagnosed with dissociative identity disorder. I was unable to work. I was in and out of psychiatric care in hospitals, and this is very well documented. My former psychiatrist who did the diagnosis can testify to all of this. So I am asking that we address the arrears also, because I was unable to work. I was very, very sick.
All right. Did you file any motions, or is this the first time you've filed anything to address the arrears?
I filed the objection to the arrears.
All right.
For a little bit of background, dissociative identity disorder, I suffer from blackouts. They last a long time. I'm very confused on what's happened the last few years. The only thing I am very certain of is I have been receiving a lot of psychiatric care, and it's been impossible for me to work because I have gone and received care. I have the diagnosis. I am now in therapy. I'm ready. I'm getting back to work now. I've gotten through it. But up from the time I was 13 until 2022, I was very healthy, very normal, no mental issues whatsoever. I suffered a major breakdown. It has affected my life the last few years, and I am getting back on track.
All right, Ms. Bagby, I'm going to preserve that argument. We'll prepare a new recommendation. Then we'll address that argument after that new recommendation and an amount on arrears is addressed, but I will preserve your right to make that argument. I don't know with the timelines and what has gone on, whether or not that argument can legally be made, but I will preserve your opportunity to make that. So I'm not taking away that opportunity. Okay. All right. All right. Thank you both for appearing. You're all set.
Thank you.
We're next call the matter of Thomas LaForest and Rebecca Ledbetter, file number 19-17998DM. We have the parties on that matter present.
Here, Your Honor.
I'm here, Your Honor.
All right, thank you. And ma'am, this is your objection to a child support recommendation, is that correct?
Yes, sir.
All right, let's go over your objections.
Sure.
What's your first objection?
I'm sorry, go ahead.
What is your first objection?
Oh, to the child support amount, and the calculations. Wondering, why, since I've gotten overnights, the, child support went up, and I thought the calculations were wrong, so I did that, yeah.
So let's just be clear. So what do you think is wrong in the calculations, one by one?
Okay. Okay, one by one. So, I have just moved. I'm still in Crawford County, but it's Roscommon. It's in a better place, a better area. But on Sundays, I had to have the Swamp, the boss, she helped me get into this place. So on Sundays now, all my money is to her. So that is different. My hours have been a little bit lower. And I'm worried that if having to spend, I would give my son every penny if I could, seriously, but it takes away from the time, the gas to go get him, or the play time.
Well, man, I'm going to just ask you some questions so we can maybe address it more simple that way. And your audio is horrible. So we may adjourn this matter, just have you appear in person if I don't get better audio and can hear clearly, because make sure I'm all the information and that it can be transcribed. So I'm looking at your written objection.
Okay.
First thing you say is I am receiving more overnights. So what would you like to say regarding that?
Well, at that time I was getting more overnight, like as many as I could. So I don't know, I felt like 52 wasn't enough. Like that, I felt like I was getting more.
All right, Mr. LaForest, how many overnights does Better get?
She gets one overnight a week.
And it should change. It's been
That's what I
3 or
s-
4 years.
Well, I see a mediation agreement from August of this year. Well, I guess you mediated in June. It was signed by the court in August, but there's a mediation agreement of June of 2025 saying that you would have the child on Thursday nights. Is that correct?
Correct, but that was during the summer, so it has changed to Friday nights. But
Okay.
I was hoping it would be Thursday, Friday. I'm hoping it would be Thursday to Saturday would be in the next mediation. I mean, I don't know why I haven't gotten more, but you're right,
I'm
that
not
would be a
asking-
mediation. So
I can't prepare a support recommendation based on hopes. I'm looking at what is the order. It looks like the order says you get one night a week. Is that what you're following? You're having one night a week?
as of now, correct.
All right. All right, so that deals with that part. And then it says, it talks about how much you have left over. That's not necessarily a reason to change. It says that you feel that Mr. LaForest had received a bonus and a promotion recently. And we might
And a
not have
raise.
and we might not have his income correct. So, friend of the court, did you get information from Mr. LaForest regarding his income, or did you have to seek it up elsewhere?
He did not turn anything in. I did use business objects and used the average of 4 quarters to determine his income.
Mr. LaForest, did you receive a bonus and a promotion?
And a raise.
I did receive a promotion, Your Honor.
Okay. So has your income changed recently?
Yes, sorry, I have not updated my income, but yeah, I'm currently making $35 an hour.
All right. So we will recalculate that issue. And then, ma'am, you have an issue with your income?
No, well, yes, I have a question. How do I report my Sundays if I am owing back money for a loan, from a loan?
Yes, because you're making income, so you're paying a loan off, but you're earning that money.
Well,
It's just going to something else.
It's going to
Right.
the person of the, I'm not getting the cash. It's going directly to the owner of the restaurant.
Right, but you got that cash at some other point, so you're paying off a loan, so that is income for you because you're paying off a debt.
Okay. Okay, that's okay. That's fine.
Okay.
Okay, thank you.
I'm looking at written document, then it also mentions, well, since he only has one child, are you saying that was incorrectly calculated in the support guideline, or you're just making that point?
Well, no, he's got stepchildren, but I believe that it was noted in the calculation he had more than one biological. And I was just stating the fact that he only has the one biological with me.
Okay. So I do see it, sir, on your form, it says total other children listed as 2. Is that accurate?
Is that for me, Your Honor?
Yes. Is it accurate that you have 2 other children? Are they biological children or stepchildren?
They are stepchildren, dependents.
They're not adopted or anything like that, correct?
No, Your Honor.
Friend of the court, was that your understanding, or was your understanding something different?
Because I didn't have any information from him directly, that was information I had found when I was doing research with his insurance and found that he had the extra kids that are on that grant, but if he only has one child, I can certainly make that correction.
Right, so for the calculations, it's additional children include biological or adopted. We'll make that correction. All right, and then did you have any other issues, Ms. Ledbetter?
Let me think. I believe oh, what was the other calculation? I No, Your Honor, honestly, I did, but obviously I can't think of it right this second. Yeah, I noticed a few different, actually I got the calculations in front of me. I can take a look for it. So I know it's based on my gross. It's and getting overnights, because last time the calculation was, it says 196. And I was, oh yeah, my question was health insurance. I'm so sorry. Um, can he be on my Medicaid instead of his work health insurance that I seem to have to pay?
No, if there's private insurance available, then that's where the coverage would go. And Mr. LaForce, have you provided the insurance throughout?
My son just recently started on my health insurance plan, maybe a month ago, a little over a month ago. And I pay approximately $57 a week for him to have health and dental.
That's through your work?
Yes.
Well, I don't know why I got something in the mail. I got his Medicaid card. It says that I'm the beneficiary. I'm really not sure why I got all that then. And it said that he was approved for my Medicaid.
All right, well, I'm not going to change the health insurance credit because the formula does indicate that if a party has private coverage that is accessible and at a reasonable cost, then the court should have that party be the one providing the health care.
So I would have to pay that?
It would be a part of the child support formula, yes.
Instead of him being on mine, unless I file that motion to get my sole physical and legal custody back.
Yes, ma'am, we're not going to grant that. So I think that covers everything. So we'll prepare a new recommendation based on those changes.
Sounds good.
Court, any questions?
With Mr. LaForest, if he could get in contact with me maybe this afternoon, I do have additional questions that I would need.
So sir, you need to reach out. You're probably gonna need to provide some recent pay stubs also, okay?
I can do that.
All right, thank you both for appearing. You're all set.
Thanks.
Thank you, sir. Bye-bye.
The court would next call the matter of Cole Dickinson versus Tabitha Alexander, file number 22-18986 DP. Do we have the parties on that matter present?
I am here, Your Honor. I see Mr. Dickinson present. I didn't expect the defendant in this matter to appear. The defendant is Tabitha Alexander.
Thank you. I do not see Miss Alexander present. And Mr. Backlund, this is your motion, correct?
Yes, this is our motion regarding custody and parenting time. This is a little unusual of a case, Your Honor, so some procedural history might be useful. This was opened back in 2022 as a DP to establish Mr. Dickinson's paternity. There was an NA case in the Otsego County Probate Court regarding the two minor children that Mr. Dickinson has. They were removed right after birth from Miss Alexander, and so we needed to establish paternity for Mr. Dickinson. Meanwhile, the NA case continued to be ongoing. The order of affiliation was entered in 2023. There was a temporary order regarding legal custody in 2024, granting that to Mr. Dickinson so that he could provide approval for a procedure that the girls needed while they were still in the care of DHHS. The defendant in this matter, her rights to the minor children were terminated in October of last year. In November of last year, DHHS granted custody to Mr. Dickinson in that NA case. There were several months of just monitoring with the Michigan DHHS and Oklahoma DHHS. That's where Mr. Dickinson and now the minor children are located. And then the probate court here in Otsego County terminated its jurisdiction in summer of this year after it was satisfied that the girls are safe, happy, and healthy with Mr. Dickinson. So essentially the purpose for today's motion to establish that custody and parenting time with Mr. Dickinson is to close the loop on this case because we don't have a final order regarding that custody and parenting time in this case has still remained open, although the NA case was terminated, and understanding anything in the NA case would override what we do here in the family court. Now that that's over, we've sought to then, like I said, close the loop on this case with an order granting Mr. Dickinson that sole legal, sole physical custody, and then the 365 overnights a year.
All right, so we would have to take some testimony on the best interest factors. Don't know if we've got necessarily the time to do that right now. I'm looking at my docket. Got a few cases every 15 minutes. I don't think we would need a lot of time probably to go through the best interest factors and establish the history.
Okay.
Do you have any issue if I set it for another date and just give you a quick kind of 30-minute time frame to make that happen? And I would allow your client certainly to zoom in for that.
That would be acceptable, Your Honor, whatever the court needs from us.
Okay. All right, I got January 21st at 11. Are you available that day?
I will pull up my calendar right now. I am, yes, I'm available that day.
All right. So we'll set the matter for January 21st at 11. I'll allow everyone to appear by Zoom for that hearing, given the situation.
Okay.
Just take some testimony on the best interest factors and then make a decision.
All righty. Thank you, Your Honor.
Thank you. We'll next call the matter of Alexandria Robson versus Casey Lill, file number 25-20176 DC. Do we have the parties in that matter present?
Yes, Your
Yeah.
Honor.
I'm
Thank you.
here.
This is an initial hearing to address custody, pairing time, and support. Ma'am, you are the plaintiff, so I will ask you first, do the two of you have any agreements at this time when it comes to custody, pairing time, and support?
No, there hasn't been any agreements made.
All right, and what are you requesting as far as custody, pairing time, and support?
Full custody, physical and legal, and for him to have supervised visits until further notice.
Okay. And sir, are you in agreement or disagreement with that?
Disagreement, Your Honor.
What type of custody and pairing time are you requesting?
1 week on, 1 week off. Something along them lines, 50-50.
Okay. Things real quick. The two of you live in the same area or different areas?
Different area now, sir.
Okay. Where do you live, sir?
Roscommon at the moment.
Okay. All right, since there is no agreement, what we would do is we set the matter for a hearing on those issues. That is an in-person evidentiary hearing. Ma'am, I'll ask you first, do you intend to call any witnesses or just provide your own testimony?
I'm sorry, sir. Were you asking Alex?
Yes. So ma'am, do you intend to call witnesses or just provide your own testimony when we have a hearing on this issue?
I'll have to ask my lawyer.
All right. I don't see a lawyer listed for you. Do you have a lawyer or you plan on hiring a lawyer?
I need to hire a lawyer.
Okay. And sir, do you intend to call any witnesses or hire a lawyer?
Yes, sir.
You intend to both those things, or? Sorry, that was a bad question that I asked. Do you intend to hire a lawyer?
Yes, I do. And at this moment, no witnesses, but that could be left open. it was more of a, visitation, I guess now we should say, just because it's been a few months, so I definitely do plan on hiring a lawyer, very quickly, within the next week or so.
Okay. So that I can get the two of you in court on January 15th. Do you guys want more time to speak to lawyers, or do you want that time?
Is there any way that you could set a visitation date now? Since it's been 2.5 months since I have seen my daughter? Just
Well, if you
wondering.
guys reach an agreement, you guys can come to an agreement. If you guys can't come to an agreement, I have to have an evidentiary hearing to determine what's in the best interest of the child. So she has requested supervised parenting time.
Yes, sir.
Are you willing to have that start now, Ms. Robson?
Oh, me? Sorry. Supervised visitation, I would agree to right now, yes.
All right, sir,
But
would you?
EPO in place with being Casey.
All right. Would you agree to supervised parenting time right now, sir, pending the hearing or not?
Yes, sir.
Okay. So ma'am, who do you think, when you say supervised, what do you envision? What does that mean to you as far as who's supervising parenting time?
That he needs to provide an approved, somebody that we can both, that I can agree with to be at the supervised visits with him the whole time. For there to be a time limit for each visit, maybe like 2 hours. Maybe,
Okay.
yeah.
Do you have any suggestions as to a supervisor? Is there anyone in his family or friends that you think is appropriate?
His mom, I would trust.
Okay. Sir, do you think any reason why your mom can't supervise visits?
No, sir. No, Your Honor.
Okay. All right. And then, so ma'am, what are your thoughts on days and times that it could happen?
Probably every other weekend. In the afternoon, like, maybe like 4 to 6 o'clock.
So what are your thoughts on dates and times?
Every weekend, something like that, or I guess, yeah, every weekend, or at a time that would be convenient for her. So I mean, around 4 or 6 would be a decent time. Obviously, if there's not room for overnight or anything like that.
Okay. So ma'am, does a child, I mean, child's young, so the child probably doesn't have any activities on weekends, correct?
Correct.
Any reason they can't do it every weekend until we get to the court hearing?
I just work weekends, so that's what I was suggesting, every weekend or every other weekend.
All right. You work every Saturday and every Sunday?
Yeah.
Okay. So what was your plan on how your thought that he would come pick the child up from your residence or his mom would? What was your thought on that?
Yes.
Okay. So man, it is pretty limited time. So do you see an issue if he's doing the transportation for having it every weekend before we have that hearing?
I'm sorry, what was that?
Given the amount of time that we're looking at here, do you see an issue with it happening every weekend? It sounds like you're at work anyways, correct?
No, I'm at home right now.
No, on the weekends, you said
Oh.
you work every Saturday and every Sunday, correct?
Yeah.
Okay.
I guess
Any
I
reason-
agree to every weekend.
Okay. And you think 4 to 6 is the best time?
Yeah,
All right. So is he allowed to come to your residence or not?
no,
Based on, yeah, okay. So sir, would your mom be able to pick the child up? I mean, you could be somewhere else, she could pick the child up, and then the two of you could be together with your mom for that time frame. Is there any issue with that?
No, I can make that work.
All right. And man, there's nothing preventing his mother from going to where the child is and picking the child up?
correct. That would be fine.
And would the child be at your residence?
Yes.
All right. And we're gonna do Saturdays.
Okay.
Is that okay, or is Sunday better?
Saturdays is good.
Okay. All right, so we're gonna set it for a hearing on January 15th at 9 a.m. That is a in-person hearing. So you are here in person for that hearing. If you hire attorneys and they have conflicts that date, you need to make sure that that is dealt with immediately.
Yes, Your Honor.
They need a different date. You also have to file a witness and exhibit list 14 days prior to that hearing date. That information will be provided on the notice. Then we're going to do a temporary order real quick. Ms. Robson, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. So ma'am, is it correct that pending a hearing, you are agreeing that dad would have parenting time every Saturday from 4 to 6, supervised by his mother?
Yes.
And his mother would come to your residence to pick up the child and drop off the child. Is that correct?
Yes.
You understand that this is just a temporary order at this time, pending a hearing?
Yes.
And are you making this decision freely and voluntarily?
Yes.
Thank you. Sir, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, are you also asking the court then to enter a temporary order pending a hearing on this matter that would give you parenting time every Saturday from 4 to 6, with that parenting time being supervised by your mother?
Yes, Your Honor.
And what is your mother's name?
My mother's name is Stacy, Stacie, Prelop, Prelop.
Can you spell that one more time?
Stacy, Stacie, Prelop, Prelop.
Thank you. And then you understand, obviously, that you can't go to the residence given the PPO, so your mom would have to
Yes,
pick
sir.
the
I
child
wanted
up.
to see if I can make a
All
note
right.
on like the car seat, if that's something that we could share, or just when I come to pick up the car seat, it'd be with my daughter.
Need to have your own, I believe.
All right, well, if there's no agreement on a car seat, then it's your obligation, sir, to make sure you have the appropriate means to transport the child during that parenting time.
Yes, sir.
All right, then, we'll see you all back here on the 15th then for your hearing.
Thank you.
And then that parenting time, ma'am, any reason why you can't start this Saturday?
No objections for me.
That's fine with me too.
All right, so we'll indicate that parenting time will start this Saturday. All right, thank you for working together on that issue. And like I said, we'll see you back here January 15th.
Thank you, Your Honor.
Thank you, Your Honor.
We next call the matter of Hunter Crowderfield versus Haley Crowderfield, file number 23-19399DM. We have the parties on that matter present.
Yes.
Yes.
Thank you. We do have both parties present. And I'm sorry, ma'am, it is now Nicholas. Is that correct?
Yes.
All right, thank you. And Ms. Nicholas, this is your motion. What are you looking to
Yes.
change?
I'm asking to add the attached amendments to our parenting plan. legal decision-making such as educational placement and extracurricular activities, just notification of medical care and co-parenting counseling, because we have had a lot of on and off issues with trying to communicate with co-parenting, and I think it would be in Zoe's best interest that we can get on the same page with co-parenting.
All right, so currently, the two of you have joint legal custody?
Yes.
Okay. So you're just. So you're currently ordered to have that communication. Are you just indicating it's not happening, or what are you looking to do?
It's very on and off and one-sided, so I'm really thinking that we need to get to the bottom of it to where we can both communicate effectively. Like with educational, we now can't agree on a school when we had previously talked about it and agreed what we wanted to do. He enrolled her in competitive cheer without talking to me until her first day of it on his week. And with the co-parenting counseling, it would be nice to get to a point where we can co-parent effectively.
Was the school matter an issue for the court to address, or is that resolved at this time?
It's not resolved. We both have conflicting views on that now.
All right, is the child in sort of any schooling yet or not?
I'm trying to get her enrolled into a preschool at the school I would like her to go to, but he doesn't even want her to go into that school system now when we have talked about it previously.
And you're asking to try and go to mediation to address that?
Yes.
Sir, any issue with going to mediation to address these issues?
I guess I'm just confused as to, I mean, you want to get on the same page, let's get on the same page. Let's talk about it, let's figure it out. You had your idea of a school and I had mine. Great. We put our two ideas together. Let's talk about it, let's figure it out. Instead, I just get just a bad response from you, you know? I mean, yeah, I'm open to checking this or that out. Okay. But just because I have other thoughts on things doesn't mean we can't sit here and talk about it over text like we could. That's I feel, I guess if we have to go to mediation over just simply talking about it amongst ourselves, I guess I don't have a choice in that, but I feel
Well, I mean,
like,
mediation obviously gets you, a third party that's there to help the conversation flow and be, they're trained in those, making sure that parties are having some productive communication. It might help the two of you if there are communication issues, to have that third party there to kind of keep everybody on point, move things along. And
well, yeah, because there's definitely communication issues. I mean, we can't even talk about anything at this point in time because it's, if she's got an idea and I got an idea, it's like we just can't come to a resolvement instead of just sitting there talking about it and trying to figure it out with one another. It's I guess one-sided apparently.
Are you okay trying mediation then to see if you guys can reach some agreements on these issues?
I mean, if we can come to an agreement on some things if that don't make an agreement, yes, I do agree with that. However, the co-parenting counseling, I don't agree with that. I don't see us needing that. That is, I feel we can definitely resolve a lot of this amongst ourselves. I mean, we really don't, if we can effectively communicate, we should not need that at all.
Okay. Well, I think what the appropriate thing to do is to refer the two of you then to mediation, see what issues you can come to an agreement. If there are other issues that need to be addressed, then potentially have a hearing on those issues. So we'll do a referral to mediation and then set a status conference for a date after that mediation. We'll hear back to see what got resolved or didn't get resolved, and then decide what, if a hearing is needed or what the next step is. Okay.
Okay. Thank you.
All right. Thank you both for appearing. You're all set. Next call, the matter of Andrew Sigafus versus Adriana Norman, filed number 24-19762 DC. Do we have the parties on that matter present?
Yes.
Yes.
I know previously you had attorneys. Do you have attorneys that are representing you still or not?
Yes, mine is trying to get logged in.
Okay. Sir?
I still have my attorney also. He is on a 3-day jury trial right now. So he was wondering if we could get an adjournment.
All right. I do see, man, that your attorney has joined us. I'm letting him in right now. All right, Mr. Lavoy, I have called the matter. If you could please place your appearance on the
morning.
record.
Martin
Good morning.
Levois on behalf of Adriana Norman. Thank you.
Thank you. So counsel, Mr. Sigafus indicated that his attorney is currently in a 3-day jury trial and not available. This was a status hearing to address the final custody judgment. Anything that you can tell me as of now?
Yeah, well, Your Honor, my client's position has always been that she's insisting on 50-50 parenting time. I don't believe there's any reason not to have that granted, and that's basically our position at this point in time. Up to now, we've just been going back and forth with child support and whatnot. We did at one point in time with the mediator, we're able to increase my client's parenting time, but there's a 1-day discrepancy, Your Honor, or 1-day difference, and I don't even really understand the significance of that. But having said that, my client just wants to clear up that 1 day that is requiring her at a lesser income to pay the plaintiff $50 a week. So she wants and always has wanted 50-50 parenting time, and that's our position. Hopefully we're hoping to stipulate to that, but without Mr. Guru Murthy, I don't know that we'll make much headway today.
No, I don't think we can. I see that there was at one point, looks like the custody arrangement that was put into a stipulated order. And that's what that was back in the end of last year. Is that what the parties are still following as far as parenting time?
That is what was managed through the mediator, and that's what they've been exercising since.
Okay. And then I know we've gone back and forth with some of the support orders, but I think those finally made it through and got signed by a judge. Is that correct?
Yeah, I believe so, Your Honor. I know that my client filed a motion trying to address that. It was denied, but there is a support order entered. Yes.
So I think really what the court's looking for is then to have all that incorporated into a final judgment. I mean, essentially right now there is an order regarding support. There is an order regarding the custody and parenting time, but we don't have that. Those went piecemeal, so we're looking for that final order with all the appropriate terms. Do you think you and Mr. Guru Murthy can get that together?
I don't think so. With the one issue hanging out there, my client is going to probably want to petition the circuit court to get that relief.
Well, she'd still have that ability. The problem is we don't have a final order. There's an agreement as to what parenting time and custody should be based on paperwork.
Your Honor, you're kind of breaking up a little bit. I think I get the gist of what you're saying. That you are you saying that we need to draft a final order that she can object to?
Yes. You guys have agreements on everything already. So if she's looking to change the agreements, the court's looking for is that final order that says this is where everybody's at. She certainly has the right, obviously, then at any time to petition to make changes, but we've never had that final order. Or Mr. Guru Murthy could submit it under a 7-day rule too.
Maybe I'm mistaken, Your Honor. But we are trying to resolve the parenting time issue before a final order got entered. Just procedurally, it's a little easier to deal with.
Sure. Absolutely, yeah, if you have any, be great, and that would be, like you said, much easier. So what I'll do is I will adjourn this 30 days to get the new status, see if the parties are able to get together on an agreed upon agreement. And then certainly if you're not, then either party would have the ability potentially to file, a proposed judgment under the 7-day rule based on what those current orders are. But that's what we're really looking to do, is clean up and have that final judgment in. Okay.
Yeah, okay, I understand. I will talk with Mr. Guru Murthy and proceed from there. I just may have him go ahead and submit a 7-day. I don't want to stipulate to that and cause another issue, but I understand what you're saying, and we'll talk about the issue and have a final order entered so we can proceed from there.
All right, thank you. I appreciate that. Parties are all set.
All right, thank you for your time, Your Honor.
Thank you. Next call is the matter of Jaslyn Parrott Gauthier versus Adam Becker. File number 18-17120 DP. Do we have the parties on that matter present?
Yes, Your Honor.
Yes, sir.
All right. I have in front of me a mediation agreement. Ma'am, does that mediation agreement resolve the issues in this case or not?
Yes.
And sir, do you agree that it resolves the issues in this case?
Correct. The reason one of the reasons I filed thing is she picked her up on her birthday. That was the main reason for this hearing. She picked her up from school without permission or without me knowing that she picked her up, and I showed up to the school to pick her up, and my daughter was not at the school.
Are we considering that issue resolved, or are you requesting something to happen regarding it?
Well, as long as I guess the issue was resolved.
Okay. All right, so in looking at the mediation agreement, indicates that you agree to share legal custody. Keep each other informed, agree to discuss and follow recommendations for treatment, that Mr. Becker would be the primary custodial parent, that Ms. Gauthier Parrott would have parenting time every other weekend. In the summertime, share a week on, week off. Share holidays, says, and utilize the schedule you have in place. Mom would have a call, it looks like on Wednesdays at 6 each week. That for 2025, Ms. Gauthier Parrott would claim the child on the tax return, and then that Mr. Becker would claim her the following years. Does that sound like your agreement, Ms. Gauthier Parrott?
Yes.
And Mr. Becker, does that sound like your agreement?
Yes, Your Honor.
And as to child support, was there any discussion regarding child support?
No.
I know sometimes child support's based on like her Medicaid and medical. I carry my own insurance for our daughter, so I'm not asking for any child support.
All right, looks like it was previously ordered at 0, and you're just asking that that continue?
Correct.
Okay. All right, ma'am, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
And ma'am, are you asking the court then to adopt that mediation agreement? Looks like it was from November 6th of this year.
Yes.
And are you making this decision freely and voluntarily?
Yes.
And you believe it's in the best interest of your child?
Yes.
Thank you. Sir, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Sir, are you also asking that the court adopt the mediation agreement from November 6th of this year?
Yes, Your Honor.
And are you making that decision freely and voluntarily?
Yes, Your Honor.
And do you believe that's in the best interest of your child?
Yes, Judge.
Okay. All right, so the court will indicate then that the mediation agreement is adopted. There is no need for a new support recommendation, as well as any parenting time complaints are resolved. So no additional hearings on those matters for the ones that have existed prior to today's date. Any questions, sir?
No, sir.
Any questions, ma'am?
No, sir.
All right, thank you for working together, and thank you both for appearing. You're all set.
Thank you, Judge.
We'll next call the matter of Cassandra, matter of Nigel Ingersoll versus Cassandra Ingersoll, file number 23-19438 DM. Do we have the parties on that matter present?
Yes, Your Honor.
I'm here.
Thank you. And Mr. Ingersoll, these are your motions, is that correct?
Yes, Your Honor, that is correct.
And what are you looking to change?
Your Honor, I would like to establish some custody and parenting time. I felt that the responsible thing to do during my incarceration would be to give full custody to my daughter's mother. And now that I am out, I have a job, I have a vehicle, I have a place to live, it's stable. I would like to start seeing my daughter on a regular basis. However, that has to happen.
See looks like a judgment of divorce from last year. Indicated that. In-person parenting time is as the parties agree. If the parties can't agree, then either party may file a motion. Ms. Ingersoll, anything that you would like to say regarding the motions?
I would just like to make it known that he is not safe, he's not stable, he is irresponsible, he's unreliable, he is a danger to women and children. I do not want my child around him. Point blank, period.
Okay. All right, so what we would do then, if the parties don't have an agreement, is set the matter for a hearing. And ma'am, you live in Tennessee now?
That is correct, yep. And I've been down here for over a year and a half now.
All right, so I would allow you to appear by Zoom for the hearing. Mr. Ingersoll, do you intend to call any witnesses or just provide your own testimony?
I would like to provide my own testimony, Your Honor.
All right, and ma'am, do you intend to call witnesses or just provide your own testimony?
I mean, if it comes to it, I can provide witnesses, absolutely.
As I can, Your Honor.
For both of you, it's all up to you. So the issues would be what type of parenting time is appropriate. If you have witnesses to address those issues, we'd be looking really for the time period since that judgment of divorce moving forward is the big focus. Obviously, some other matters can come into evidence too, but you know, what we're trying to establish is what is the appropriate parenting time. So if you intend to call witnesses, I will give you a little bit more time than I would normally give you. If it's just going to be the two of you testifying, then I would set it for an hour. If you're going to have witnesses, I'll give you more time.
You might as well give us more time, Judge.
All right.
All right.
Okay.
He does not deserve to be around his children, and he's already got his new girlfriend pregnant. So he ain't even been out of prison 2 fucking months, and he's already got his new girlfriend pregnant.
So for starters,
I'm sorry. You're right. I apologize. I didn't mean to cuss in your courtroom. I apologize.
Also, this isn't the time for you to go back and forth about your negativities on each other. We're just simply getting matters scheduled, okay? So you can save
All
those
right, well,
arguments
I'm
for
just
the other.
saying, I was just saying, I under no circumstances trust him around my child. That's all I'm saying.
Well, Your Honor, that is our child, and I'm just here to establish a
Set- For
parenting
both of you,
time.
we're gonna set it for a hearing.
Thank you, Your
All right.
Honor.
We're gonna Set
Thank
it for a hearing on,
As far out as you could push it, Your Honor.
As soon as possible, please.
all right, I'm gonna set it for January 21st at 1 PM.
Perfect.
I will do this hearing by Zoom, given the location. Out of state. That has already been approved. That change was approved in the judgment of divorce. So we'll do that hearing by Zoom on January 21st at 1 PM. If you intend to call any witnesses or file any exhibits, you do need to file a witness and exhibit list 14 days prior to the hearing date. Additional information will be contained in the notice that you get for the hearing. Anything else from either of the parties?
No, thank you.
No, sir, I'm
See you in
good.
January.
All right, I will then see you guys back here on the 21st of January. Thank you.
Perfect. Thank you, sir.
The other one.